Thank you. Well, I'm Sherry Carter. I'm the Court Executive Officer for the Los Angeles Superior Court. And before joining the state court system, I was the Executive Officer and Clerk for the California Central District Court, the federal court system, which is where I spent most of my career. And so I welcome you today. And we're doing our own introduction, so I'll turn it over to my colleague.
Okay. My name is Paula Hannaford-Agor, and I am the Director of the Center for Jury Studies at the National Center for State Courts. I'm also a Principal Research Consultant in the Research Division at the National Center, and so when I'm not doing things jury, I work on things involving civil litigations, civil procedure.
Hi, I'm Hannah Lieberman. I'm the Executive Director of Neighborhood Legal Services Program in Washington, D.C., and we are a program that provides free civil legal services to low-income residents of the District of Columbia. We have sister programs all across the country. I suspect you guys probably work with a lot of our colleagues, and I certainly hope that you do. Those are great collaborations. As you probably know, we focus on the most destabilizing problems that affect low-income folks, including housing, lots of landlord-tenant work, high-conflict family cases, public benefits, wages, increasingly on trying to resolve problems that keep people from getting and keeping jobs, and increasingly consumer debt. So a lot of the kinds of cases that I'm sure you and your staff see frequently. Personally, before I became the ED, I've been hanging around civil legal services for a number of decades, worked in Arizona, in Maryland, and also as a consultant around the country. And so I've had an opportunity to see the challenges that our lawyers face and that judges face and that courts face in dealing with a lot of the problems and challenges that we're going to be talking about today.
Folks attending the NACM mid-year meeting. I'm Tom Balmer, and I'm the Chief Justice of Oregon. I am chair of the Conference of Chief Justices Civil Justice Improvements Committee. We've been meeting over the past 2 years and reviewing pilot projects that have been held around the country to try and reduce the cost and delay in civil litigation while keeping it a fair process. We've looked at research, we've had conversations among the 26 members of our very diverse committee, judges, trial court administrators, lawyers from all across the country. And we put together a really robust series of recommendations that we think can improve civil justice in this country. I hope you'll take a look at those recommendations with judges, other court administrators, and staff in your court and see which of these recommendations might be appropriate for you to adopt. Some of them might require additional resources, others don't, and you can do them just by changing educational practices, perhaps redeploying resources within your courts. I think together we can improve the civil justice system in this country. Thank you so much.
Okay, that was, he introduced himself, Chief Justice Balmer, and he chaired the CCJ Civil Justice Improvements Committee. That's how the three of us all know each other. Both Hannah and Sherry are members of the committee, and I was one of the principal staff supporting the committee for CCJ. And just before we sort of start talking about some of the recommendations, one of the things that to support this committee is we did some independent research of trying to look, before you start trying to tackle a problem and come up with solutions, it's actually useful to know what it is that you're dealing with. And so the National Center did a study, what we call the landscape of civil litigation in state courts, to get a handle on, exactly what are we talking about? What does civil litigation look like today? We did this by working with 10 counties around the country, 10 large urban counties, and looked at all of the civil cases. So it wasn't just in the general jurisdiction courts, but also in the limited jurisdiction courts, of where are civil cases being filed and how are they being disposed in state courts today. And as we did this, we ended up with more than 925,000 cases that we looked at that were disposed between July 1st, 2012 and June 30th, 2013. So a 1-year slice, and looked at these particular cases. We think, because these are large urban courts, that they actually reflect about 5% of civil cases that are filed annually in state court. So it's a pretty good snapshot. So what did we learn from it? First of all, I think the thing that was quite surprising, at least to me, is when you look at this particular pie chart, you'll see that almost half, we had some that were single-tiered courts, like California, that's a unified court, but a lot of our courts had both a general jurisdiction and a limited jurisdiction court, or some combination. Some of them had actually 2 general jurisdictions and 1 limited jurisdiction. We had Harris County, Texas, that's 1 general jurisdiction and 2 limited jurisdiction courts. So actually 3 courts that we were looking at in that particular county. The interesting part about this is that when you look at the cases that are being filed in the limited jurisdiction courts, the ratio between limited jurisdiction courts and general jurisdiction courts is about 2 to 1. And so when we think about civil litigation, and we think about sort of personal injury and medical malpractice and products liability and sort of these higher end tort cases, and that's kind of the tip of the iceberg. Most of the iceberg is actually happening in these limited jurisdiction courts around the country. And these data are actually very consistent with what the National Center's Court Statistics Project has found, is that there's actually a huge portion of civil cases are being filed and resolved in limited jurisdiction courts, not in our general jurisdiction courts. So when we look at what kinds of cases are we talking about? And again, sort of the civil calendars that we have in our head, that get talked about the most, tort reform, they're high-end tort, high-end commercial, business-to-business litigation. What we found when we actually looked at the case types was that almost 2/3 of the cases are contract cases. Another 16% are small claims. So between contracts and small claims, we're talking 80% of our civil dockets nationally. Then you had sort of this ubiquitous other, appeals from limited jurisdiction courts, appeals from administrative agencies, criminal and domestic related kinds of cases, writs, taxes, judgment enforcement actions, things of this nature. And so you've got that other civil. Torts were only 7% of cases, and real property is only 1%. And I think this is a very, very big change. The last time that the National Center did a multi-jurisdictional study of all civil cases, as opposed to just bench and jury trials, which we've done periodically, some of you may be familiar with that, was in 1992. That was a study that looked at, just in general jurisdiction courts, all cases, basically all civil cases. And I went back to that data set and I took a look, and in 1992, the ratio of tort to contract was about 1 to 1. In this most recent snapshot, the ratio of tort to contract is 1 to 7. And I said, so is this sort of a remnant of the economic recession? I mean, most of you probably had contract cases, that went up very high with the mortgage foreclosure crisis and a lot of debt collections taking place. And I looked at population adjusted over the last 2 decades. And contract filings, they do fluctuate somewhat with the economy. But population adjusted, they're pretty flat. Torts, on the other hand, have completely evaporated. They've just disappeared. So, just saying that. Another thing about the contract cases, We broke them down, and you could actually, there were 3 types of contracts that made up 80% of those contracts. Debt collection, landlord-tenant, and mortgage foreclosure. And this was 6 out of our 10 counties were actually in states that had a judicial remedy for mortgage foreclosure. 4 of them actually have an administrative remedy, and there were very few mortgage cases that were actually filed in those. So that's something that's very different when you think about, these are not business-to-business, commercial, fraud, employment, discrimination cases. These are actually pretty run-of-the-mill, very, very high-volume type cases. So how are they being resolved? So the upshot from all of this is that there is very little formal adjudication taking place in the civil caseload anymore. We had a grand total of 4% of cases that were formally adjudicated, either through arbitration, so an arbitration judgment that was entered, bench or jury trial, and another 1% that went to summary judgment. Most of the cases, the majority, the largest portion, were dismissed. Many of them for failure to prosecute, so they were just abandoned. Some were withdrawn by the plaintiff as a non-suit or something like that. That may have been pursuant to a settlement, but it wasn't explicitly said that it was a settlement, and we did count dismissal with prejudice as a settlement as opposed to as a dismissal. So we don't really know, but we think a lot of them, some of them are definitely settlements, but they're just not recorded as such. But the settlements themselves, so something that said settlement, agreed judgment, stipulated judgment, dismissed with prejudice, that's only 10%. In 1992, it was 63%. So it doesn't, even if you include the dismissals with that, we've definitely seen a diminution there. But judgments and default judgments, and I think a lot of the judgments that are unspecified are actually default judgments. So uncontested cases and defaults being entered. Enough about this. But lots of uncontested. The cost. These were the judgments that were entered, and it reflects about 2/3 of about over 600,000 cases. And what we see is remarkably modest amounts. In fact, this is showing the median. For those of you who go back to your undergraduate statistics, the median 50% or higher, 50% or lower. So here you've got the median judgment amounts. Tort was only 6,000. Contracts were less than 2,300. Real property. We're talking people's houses, right? Less than 13,000 is the median judgment amount. And that's judgments exceeding 0. So if it was equitable relief or something like that, that's not included here. So you say, okay, so 50% of these were more. Well, if you bump it up to 75% across the entire thing, 75% of all civil judgments were less than $5,200. The high-end money that people think we're doing, the percentage of judgments that exceeded $500,000, 0.2%. We don't have high value, monetary value cases. Maybe they're being arbitrated, maybe they're not being filed, but they're not showing up in our courts anymore. Representation status has also changed a great deal in the last 3 decades. Tort cases were the only type of case that you had a bare majority of attorneys representing both sides. All other case types, you had this great asymmetry. Plaintiffs overwhelmingly represented by attorneys, even in small claims. 80% of small claims had an attorney for the plaintiff. On the defense side, typically between 12 and 20% of defendants are represented. So you've got this very large asymmetry. That's a very big difference from 1992, at least with the civil justice, and that was, again, general jurisdiction courts. But what we were seeing there, defendants less likely, but it was still at about 90%. Here we've got 3/4 of our entire civil caseload have at least one unrepresented person in the case. So you can see this is from the 1992, where that difference is. And then there's the issue of sort of timelines. We're all very concerned with the timeliness of civil justice, and some of you may have remembered in 2011, NACM, CCJ, COSCA, and the American Bar Association all adopted new model time standards. And these were sort of an update from the 1983 time standards. These were sort of the 1983, they were sort of arbitrary numbers that were pulled out of somebody's hat, but they didn't really match what we knew cases to take. So these were the 2011 model time standards. Are supposed to be more empirically based. If this is achievable. Well, we're not achieving it even now. Only at the 6-month mark are small claims just barely making it. At 6 months, 75% of civil cases should have been disposed. Small claims came in at 76%. The rest of them fell far short. None of them, no case type, made it at the 1 year or the 18-month mark. And so we've got lots of cases, not a lot of adjudication going on, languishing for long periods of time, with litigants that, at least 3/4 of them are probably fairly unsophisticated. With low level, one of the things that we talk about sort of who the litigants are, and they can't afford a lawyer, many of them can't. But when you look at those judgment amounts, it's also a rational decision on the part of defendants, because hiring a lawyer to defend a $2,000 credit card debt collection would cost you more than the judgment. Now that $2,000 debt collection should not be anything, or it should be something less than $2,000. So there are issues associated with that. But one of the things of these are people who ought to hire a lawyer. Well, no, it makes no economic sense to hire a lawyer under these circumstances. So I'm going to now turn it this way and have Hannah talk to you a little bit about what we do know about the litigants. It works.
Mastered. We're a little technologically challenged here. So I want to focus on what I call the high volume dockets, where most of the cases that Paula was talking about, indeed millions nationally every year, are being processed. And I'm sure they're very familiar to you. Landlord-tenant dockets, consumer debt, and in states that have judicial foreclosure. And I thought it would be helpful to just review who the litigants are in these cases, probably very familiar to a lot of you, or to your staff who are really on the front lines. And as Paula's data show, there is an incredible imbalance in the parties. As the landscape data indicates, virtually all of the plaintiffs in these cases who are businesses or other entities, they're represented by lawyers. The lawyers and the businesses tend to be repeat players who really know the ins and outs of the dockets. They probably know you or your staff. They're very comfortable. They kind of can take charge in the courtroom, right? right? I see some nodding heads. On the other side are defendants who, as the data show, are unrepresented in some of these courts. 98, 99% of the defendants don't have counsel. And who are these defendants? They are typically persons of modest or low income, which is really not all that surprising considering the fact that these dockets are really focused on problems that emerge from financial struggles, right? Landlord, tenant, debt, foreclosure. And often these litigants have other barriers that I'm sure you're familiar with as well. I frankly am shocked when I realize how many of our clients and the litigants in these dockets are functionally illiterate. They can't read and write English, even if they're native English speakers. It's astonishing and eye-opening in this country now, but it's what we see, and I suspect some of your clerks also see it. So a lot of these litigants have limited English proficiency. We're seeing more and more clients who have mental impairments, cognitive limitations, very hard to deal with if you're dealing with formal processes, as we do. Folks from other countries, other cultures may not understand the system. They may be distrustful of authority. They may be fearful, not understand the consequences, so that these litigants are really among the least resourceful in our communities. And I know Sherry has some interesting statistics from LA to kind of bring this to light.
Right. So part of what I'm going to do today is to give you specific court examples so that you can take it back home and see if it will work for you. We have a Shriver housing project in Los Angeles. We're one of a few courts in California where a filing fee was added to the initial filing fee to fund a project that would have lawyers provide self-help or limited scope legal assistance or full representation on landlord-tenant kind of eviction cases. And they just completed their first report, and we found that their clients, so the type of clients that Hannah was talking about, 62% are female, with a great majority of them having minors in the household. 1/3 of them had a high school diploma or less. A fourth, 25% of them, had a disability. 25% of them had limited English proficiency, and their average monthly income was $1,145. And if you did the median, it was $1,000. Their average median income was $1,000 a month. So these are people that really are being thrust into a system with kind of professional plaintiffs, and they're not sure exactly what it is they need to do.
So, and having heard that most of these cases involve what to most of us seem like relatively small amounts of money, you may ask yourself, so why does this matter so much? Well, at least in my view, it matters a lot. And the consequences of these cases can be hugely significant to folks' lives. Some of those consequences occur after people leave the courthouse. So you may be familiar with some, but I think it's helpful to understand how the experience in the court really plays out in folks' lives. So when a judgment's entered against someone, they can lose their home, obviously, if it's an eviction proceeding. So they lose their shelter. Their kids are in jeopardy of being taken into foster care. Their wages may be garnished. Their assets may be seized. And Sherry's statistics just underscore how low those wages tend to be. So for already marginal folks, that literally does mean food on the table. Their credit records are tainted. And increasingly, and I bet you've seen this, professional data miners look at court records and mine them and sell that information to employers, to landlords, and folks get denied jobs or denied housing because they have bad credit. They can't get a car loan, they can't get a used car, they impair their ability to get or job. They may not be able to get school loans. So there are these cascading consequences that occur from entry of a judgment. And I don't tell you this to evoke tears. I think it would be great if there were a lot of sympathy. But I think I tell you this because it's very interesting to me how it underscores how the courts, whether or not they want to be, whether or not this was originally intended, are really tied to the most fundamental aspects of lots and lots of people's lives, and how the actions that occur in courts really affect fundamental needs. So, not all tenants or poor people are good or responsible. If you don't pay your rent, your landlord is entitled to evict you if there aren't bad conditions. But given these consequences, I think it's important that we all try to get it right. And so the judgments that are entered are really well-founded in fact and law. Because when they're not, and the data shows, unfortunately, that many are not, we run the danger of undermining the integrity of the judicial system, its credibility, particularly in communities that already have a high distrust of the court system. So those are some reasons why at the outset I just want to underscore why there is an importance to these cases that may transcend their immediate appearance. So, having painted a quick picture of who the litigants are, we're going to take you through very quickly some of the most recurrent pitfalls that they face. And these are gathered from information all over the country, so they're not particular to a particular jurisdiction. We tried to find pitfalls that are really experienced across the board. So the first set of pitfalls occur before litigants even get to your door and may prevent them from getting to your door. And that is that there is still an astonishing rate of folks who simply don't get notice that a lawsuit's been filed against them. They're not served. And we continue to see cases of rampant, what you may have heard called sewer service, that occur across the country. Some on a massive scale. California, I think around 2009, a massive case against JP Morgan, which also included extensive sewer service. In Minnesota in 2014, there was a really big case of a large company that just simply did not serve hundreds and thousands of folks. And in New York, 2009, the AG, now Governor Cuomo, went after similar big process servers for just rampant false service of process. And in fact, the landscape study, Paula's study, even without getting to the issue of fraud, found that our current methods of serving folks was functionally obsolete. So this all happens outside of court. Why is it even the responsibility of the court or court staff to deal with it? Well, for one thing, you have some very important eyes and ears for flagging when this happens. Plaintiffs come in, sometimes I'm sure you've seen them literally with filings that can number in the hundreds in one fell swoop. And then they go into these courtrooms and they ask for default after default after default after default after default. And I don't know if your experience is like the ones I've seen across the country, but there are certain chronic actors for whom that happens all the time. And I suggest to you that those are some pretty obvious red flags that maybe it behooves the court and the judiciary to take a harder look at the cases that those particular recurrent plaintiffs bring to court if the default rates are just so astonishingly high in those dockets. So you have a wonderful vantage point to help notice and work with judges to address those problems and put those plaintiffs to the test. In our recommendations that you will hear later, and in the report that will emerge from the Conference of Chief Judges, there are a variety of other recommendations that courts can use to try to deter this kind of bad service. No, this is-
No,
Next.
Okay?
There you go.
So the next problem, let's say folks are served. What are they served with? And what we find is that the papers filed by plaintiffs, and this is particularly true in the debt collection area, and you probably started to read a lot about it because it is getting a fair amount of press now. Papers that they file are often wholly inadequate, and there's studies that were done by the FTC, by the Federal Consumer Protection Board, by some local entities, and recently by the Human Rights Watch, that document massive inadequacies in the pleadings of debt collectors. And it is largely due to the nature of that business, the fact that they buy portfolios of delinquent debt, of hundreds of thousands of debt in a bundle, and just file complaints in chunks of hundreds, sometimes thousands. There was a court in Texas, I don't know if anybody from Texas is here, that had to limit debt collectors to no more than 500 complaints a week. So with this volume, you can understand why there isn't much of any attention paid actually to the content of these pleadings. So what do we and all these studies see? We see the wrong person sued on a pretty regular basis. We see debts that are incredibly stale, that are barred by limitations on which they shouldn't be suing in the first place. We see debts that the plaintiff can't prove that they own because they may have bought it from another debt collector who bought it from another debt collector, and they've long lost the chain of title. So the person filing has no relationship to the original creditor and is not recognizable to the defendant because it's an entity they've never heard of. But that plaintiff can't even prove they own the debt, and indeed sometimes it happens that somebody else in the chain has already collected on that debt judicially or through settlement, or the debt was paid off. They have incorrect amounts on a regular basis, improper fees, penalties that are not legal, huge interest rates, and often are filed in inconvenient forums where defendants have no connection to the forum itself and may not be able to get there. So the next problem that people face are just these totally inadequate pleadings on which no judgment should ever be entered. So let's say the defendant gets a complaint and wants to defend it. So usually we think of the litigation process as if there are claims that are deficient, like these pleadings, that's exactly what the litigation process is for, to ferret out the inadequacies, and the claim will be dismissed, and the defendant will win. And that's certainly the traditional view of the checks and balances we expect in our system, which works generally when folks are represented, but as you've heard, here they're not. And so those checks and balances don't exist. So what happens, first of all, as I mentioned, some people don't even answer because it's not about them. It's not their debt. They don't recognize the creditor. And there's not enough additional information in these papers to flag the fact that, oh, maybe this does have something to do with something that happened to me a long time ago. And while it seems ridiculous to those of us who are involved in the legal system that you just ignore something that is from a court or has that imprimatur of formality that accompanies a pleading, a lot of people aren't that sophisticated and think, it's not mine. I don't have to pay attention to this. and they blow it off. Not a good thing, but for an unsophisticated person, sort of understandable, so a default judgment is entered. And actually there are some studies that have shown that the more information that's provided to litigants, the lower the default rate. So there is a connection in just information and the fact that folks will take the initiative to defend a case. So what happens, and this is really when your folks see these litigants, when these folks try to respond to the complaint that's filed. And, you know, they don't know what to do, they don't know where to go, they don't know what to write, they don't know where to submit their response. They probably come to the clerks in the court and often want to litigate the case to the clerk, right? I mean, I know that clerks in the courts I've been in have been frustrated by that. They want the clerks to tell them what to do, how to do it. They want legal advice. Puts your staff in a really difficult situation. But without guidance, these defendants are totally lost procedurally and substantively. They don't know what constitutes a legitimate defense, they don't know how to assert them, and they certainly don't know what might constitute a counterclaim. So, let's move on to the next step. Let's say somehow, with the help of court personnel, maybe you have a self-help center at the court, the litigant is able to file some kind of response. And they now have to move from the clerk's office to the courtroom. Another area where there are just innumerable pitfalls. Often, I suspect you're familiar with this, initial roll call. Hundreds and hundreds of folks clustered into a really small courtroom. And I've seen this in D.C., in Baltimore, in other jurisdictions, in the Bronx, in New York. It's chaotic. It's loud, it's confusing. There's a clerk or a bailiff who's trying to call out the names of the cases that are on the docket for the day. There are a zillion of them. And it's hard to understand. Folks miss their name, they don't recognize the case, they don't know the number, they don't know what to do if they do hear it. Lawyers in the room are calling out the names of the defendants so they can take them out in the hallway. Very confusing, particularly for somebody who's not used to it, and folks don't respond. What happens? Defaults are entered. The litigants who do respond are then often encouraged to go outside and see if they can work things out. And totally understandable, right? This is a crowded docket. Court's never going to get through all these cases unless some of them are winnowed out. So go out into the hall and try to work it out. What happens in the hallways is probably not very visible to you, your staff, or the judges, but it can be absolutely pernicious. And my colleagues and I see it all across the country. It's been documented in studies for years now. And that is a lot of really, really heavy-handed arm twisting by the repeat player lawyers who can be unscrupulous and frankly unethical. And as a member of the bar, it pains me to say that about my fellow lawyers, but I'm not very proud of this portion of our profession. You hear lawyers strong-arming settlements by just out and out misstatements. You don't have a defense. Did you hear the judge say you have to come out and work it out with me? You better work it out now because the judge is just going to ask you to pay more. I could sit here with lots of examples of just gross, overreaching, extorting settlements with folks who may have legitimate defenses. And some of the studies have also revealed that over half of defendants in debt collection lawsuits have defenses either in mitigation or in total defense of the claims that are being brought. So it's not as though this is without real unfairness at the end of the day. These lawyers also don't often talk about what the consequences are of the settlements. They will say, it means you don't have to stick around all day. They don't tell the litigant that they've just signed a confession of judgment. They don't talk about the opportunity to just have the case dismissed. That has, as you know, enormous repercussions on, later enforcement and on the nature of the records that are created around these folks. So this hallway practice, which is really pretty ubiquitous, is a really, really serious problem. One of the worst examples that's emerged recently is something that one study called judgeless courtrooms. And I don't know if you have any in your jurisdiction, but these are when debtors come to court and meet with creditors without having, and they're ordered to do so. They show up in a room and there's no court personnel there. Nobody is explaining the situation, telling folks what they can and can't do, that they don't have to agree to something in this proceeding. The lawyers for the plaintiffs are sitting behind desks, clothed in the mantle of the court's authority, acting as though they're just an adjunct of the court, insinuating that maybe through the way they talk to the clerks or the fact that all of their files are positioned right at the bailiff's desk, that they are part and parcel of the court process, and folks are pushed to settle through just an absolute misapprehension of what's going on. So, let's say that an intrepid defendant actually resists the hallway practice and gets to trial. So what happens then? I'm sure you've seen it. Most of these folks are effectively unable to tell their stories. They want to tell a story the way we talk to our friends about what happened to us, often meander with little side discussions to put the story in context. That doesn't work in a courtroom where there are rules of relevance, of best evidence. Folks don't know how to get documents into evidence. They don't know how to deal with hearsay. That's a huge one. I mean, how often have you heard somebody try to say, well, he told me that she said, and totally objected to, and it is actually a correct objection that it's hearsay by a lawyer who knows all the rules, effectively silences defendants in their trials. Judges are then put in this awkward situation of feeling as though they may compromise their neutrality if they try to help the unrepresented party elicit the relevant facts. So even when they get to trial, these defendants can be stymied and silenced. So, as I said at the outset, these pitfalls often result in unsound judgments that are simply not based in fact or law, and often they're achieved through coercion or end runs around the rules. And I won't go into them again, but they do have serious, serious consequences. The good news in all of this is that these are not insuperable problems. We can solve them. And I think the report that's coming from the Conference of Chief Judges Committee will have a lot of very valuable suggestions that run quite a continuum on ideas that may be useful for your courts in avoiding or reducing some of these problems. But at this point, I'll turn it back to
Thank you.
Sherry.
Thank you. Paula, you said that your study had 900,000 cases.
925, 344.
Thank you. In Los Angeles, we file around 300,000 a year civil cases. So
LA was not one of our sites.
Yes, LA was not. And the reason I wanted to mention that is because we find in Los Angeles, after doing quite a bit of research, that our findings are very similar to what Paula found, not including Los Angeles. We're talking now about the recommendations that came from the Civil Justice Improvements Committee. I would encourage you to read them. They are really interesting. They have a lot of great ideas. We don't have time today to talk about all of the recommendations. We'll just take a few. But we know that it really will be up to the court administrators to make any real long-lasting changes for you to work with your chief judges, presiding judges, supervising judges, whatever model you have. I know that the recommendations feel like differentiated case management that we all know and love, but they are different in many ways, and Paula, perhaps you'd like to talk a little bit about what you see as some differences.
Well, how many of you have some type of DCM in your courts? And usually it was a natural thing to sort of, try and lump same cases together, just out of a matter of efficiency. What the committee came up with in terms of the recommendations was what we referred to as a pathway approach, and different pathways, and came up with the ubiquitous 3 because everything absolutely has to happen in 3. One of which is the streamlined pathway, the general pathway, which is sort of quote-unquote the normal cases, and the complex pathway. But instead of 2 things. One, DCM is you get put on a track and you stay there until the case is done. The pathway is that you can flip from pathway to pathway. So you could start out as a fairly simple case, and then something happens. Maybe you have another interpleader, or something else happens that wasn't apparent at filing that would actually move it from a streamlined into sort of the general, or even up into a complex. Other things in the complex, you could have one of those just big, nasty, multi-litigant cross-claims and third-party claims, the stuff that we sort of think about. And 2 of the defendants settle, and there's nothing left of the case. You don't need to keep it around in the complex pathway. You can flip it back down to streamlined because there's not that much left to the case at that point, and there's no reason for it to be getting a lot of attention. So one of the differences is that it's very flexible. And the whole idea is really trying to give each case the amount of attention, court attention and judicial attention that it needs, but not more and not less. So that right sizing the amount of attention. Flexibility, so that's getting attention when it needs it, and if it doesn't need it, then it doesn't need it, but there are some times that all cases need attention. The other piece of it is that thinking about it's not really a mountain controversy. You can have a $500,000 business-to-business contract dispute that's not complex. It's actually pretty easy. We did an evaluation, they did some reforms in Utah and sort of put civil cases on a track, different tiers for discovery. And their highest tier were cases $300,000 and up. That's what they called their tier 3, and that was supposed to get the most discovery and, And out of the cases, in contested cases, and an answer had been filed, out of those cases that were in tier 3, fully 20% of those cases beyond mandatory disclosures had 0 discovery. No depositions, no interrogatories, no request for production, no request for admission, mandatory disclosures, and nothing else. So you can't really use a mountain controversy as a good proxy for complexity. By the same token, some of these, quote unquote, low value cases often actually do have more naughty as in knots, difficult to untangle.
Oh,
Difficult to
disappointing.
untangle legal issues that actually do need to be in a complex track just because of it.
The reason I like the path approach is because the big chunk of our civil cases, as you've seen in the landscape, are really the streamlined cases. In Los Angeles, there are about 93% of our total civil filings are what we would call streamlined, and I'll get to a slide in a minute and show you that. But the way I look at it is you have limited judicial resources and limited staff resources. And if you can find ways to properly manage those streamlined cases through automation, through computers doing what staff traditionally does, having staff do what in many jurisdictions judges do, and then save the judicial resources for the cases that require judges, then you're going to have a more efficient system overall. And as long as we manage those concerns and follow the issues that Hannah has raised so that we don't just rubber stamp and push them through, that we have protections there for the litigants, I think it actually makes it for a better court system. And so that, for me, is what I like most about the streamlined, is that it allows us to manage the cases based on right-sizing the staff, right-sizing the discovery, right-sizing the time that the judge has to be involved in the case, and so on.
Okay. Well, probably the most important one in terms of the first recommendation that came out of the committee. And, traditionally, when we talk about civil litigation, I mean, the predominant one is that the lawyers control the cases, right? It's a private dispute they're bringing to a public forum, but it's really the lawyers know their cases. Well, as we see, a lot of these cases don't have lawyers on both sides. And, all of us procrastinate, I mean, if given an opportunity. And so the big one here is that courts need to take control of these cases from the time they're filing and manage the case until it is actually closed. We use that term courts very specifically. This does not mean judges. How many of you bring this back and you've seen your judges and the deer in the headlights going, I can't touch all of those cases? Yeah? That's the single most, I can't do it. I can't do individual case management with every single case. No judge, you can't. So it's the court institutionally. It is the court, it's the technology, it's the staff, it's those of you managing the cases, delegating down so that the judge's time and attention is spent on those issues that actually require the expertise and discretion of a judge, and allow trained court staff to manage the cases at other points. Legal trained, paralegal, or even simply just sort of on-the-job training, but court staff to be able to do a lot of these.
Or computers.
Or computers.
Or computers. So the point is that all cases are not the same. One size does not fit all. They have different needs, and they should be grouped by similar issues and attributes for case management purposes. I would recommend that cases be triaged at the point of filing to be placed into the pathway that it fits in so that you are grouping them. In fact, in large courts like Los Angeles, we do that. We use civil cover sheets, I'm sure you have them too, where we will find cases and they will be grouped together for case management. We have a lot of examples where we actually have now specialty courts, and we can talk about that in a little while. Smaller courts could do the same, where you may not have a full judge's docket or two, but you could do a specialty court Wednesday afternoons or Tuesday mornings where you develop right-sized procedures and right-sized local rules for certain kinds of cases that fit a certain model, because the premise is that cases with similar attributes should be grouped into specific pathways and be subject to different levels of case management and different rules that are driving the process for those cases. And you'll hear me talk more about automation, but we are trying to find ways, even from the moment someone is trying to file or interact with the court, where the computer will help triage those cases and put them in the right place. pathway assignment, we've talked about this, should be mandatory upon filing with the flexibility to transfer to another pathway should the need or circumstance change, whether it's a filing, whether it's a motion by a lawyer, whether it's a judicial determination, or whether the clerk, upon doing some case management review as part of their duties, realizes that, you know, this last filing added additional parties, or this last filing has eliminated all the parties but one, it would allow them to do that. So, you know, I talked a little bit about specialized courts. In Los Angeles, we have limited civil non-collection cases in specialized courts. We have limited collections in specialized courts. We have all PI cases, general jurisdiction cases, all downtown Los Angeles. So for the entire county of Los Angeles, we have all of our PI cases handled really in one location. And what's interesting about that, I'm probably getting ahead of myself, but what's interesting about that is that the dates given at filing for PI would be the filing status conference, the trial date, and the OSC regarding dismissal. And so we've recognized by doing research on those cases that traditionally there were only like 4 events that were ever filed on those types of cases, so we knew we could consolidate them and not have a lot of case management. And so, you know, the instant worry is, well, something's going to happen, the lawyers aren't going to follow through, we're not going to move these cases along, and that's, you know, it's a little early probably to call it a true success, but let me give you one recent example of why this is a good process, is that we had a recent jury trial come out of our trial departments that came from the PI calendar case management group. And it was, I think, a $1.6 million judgment for the plaintiff. It only had 5 hearings. So if we would have seen that as a big complex case and it had been, you know, individual calendar management and taken all the time of that judge to manage that case, the result may not have changed. And so I don't think you can use the value of what's in the prayer as an indication of how to manage the cases. I think there can be other attributes that allow us to do that. So we found that these specialized courts provide opportunities for a prompt and uniform, efficient management and adjudication of certain case types. We find that the court processes will tailor rules to meet the needs of those particular cases. It allows the cases to be processed with fewer judicial officers and staff, which then eases the burden on all the other courts, because if you pull them out and create a special court or courts for us, or maybe an individual afternoon for you, it means now that they're not spread among all of the other judges, and you've got a more efficient process for those cases. Another reason I really like them is because it allows you to do wraparound services around special cases like collections. The streamlined cases that are 93% of our docket that are primarily non-lawyered cases as the defendant, it allows us to do wraparound self-help services in those locations so that we can have mediation services, self-help services, pro bono representation in those limited areas. If they were in every court, in every courtroom, we couldn't afford to do that. But if we limit them to the number of locations, it allows us to really have wraparound services that I think helps the litigants as well. We've also found that it creates more experienced judicial officers and staff, and that I think it really helps with the scheduling needs because many of these cases have short deadlines, and if they're buried in all of the other cases, it gets the judges, they have to interrupt a trial if it's part of the regular case management rather than part of original docket that they're managing. So some of the streamlined, maybe.
Next one.
Yep, trying. Okay, we'll do it the old-fashioned way. I think we're out of a battery. Yep.
Is it, or do you just need to be behind the?
Well,
All right, never mind.
I'd like you to cut this part of the video. She's challenged. All right. Yep, that's it. So, let's see if we do it this way. All right. Triage and pathway assignments. You know, again, we've talked about this, and I don't think we have a whole lot of time, so let me go. Are you going to help me?
See if I can help it.
Thank you.
If I can get by.
Yikes. Okay, so this is a pie chart. I just hit the enter button,
Okay.
or the plus button over there.
Well, that just enlarges it. So.
Oh, yeah, that's right. All right. La, la, la. Well, so I'm going to go ahead. What we found, as I mentioned, is our streamlined pathway was 93% of our total civil filings, and so we needed to find an efficient way of handling those. Our complex filings, although this is...
Yep. No idea.
There we go.
Yahoo.
All right, thanks. All right, so here's the pie chart. It'll show you that 93%, that's the big blue, are our streamlined cases. The next slice was the general civil cases, which were 6% of the filings, and then the very small slice were our complex filings. There were only 1% of our total filings would be what we call our complex civil filings. So it kind of shows you what it looks like in Los Angeles, which is very close to what Paula found in the other cases. Oh, yay. Thank you for doing that.
No idea what it is.
Yeah, there you go. So the types of cases in the streamlined, again, very consistent with what Paula's research found. In the streamlined pathway, the collections were 29% of our total streamlined. So that would be the dark blue component. The UDs are the orange, or our landlord-tenant cases, and small claims were the light blue. So 29% collections, 23% were landlord-tenant, and 22% were small claims. And again, for each one of those case types, we've got a specialized court that handles them with wraparound self-help services in those locations to help the litigants and to try to provide some protection from the issues that Hannah had covered. There you go.
Okay. One of the things that's very different about this one is thinking about, instead of judicial, of taking the court staff and really empowering you, the court administrators, that the idea of civil case management should be done as a team of the judge with specially trained court staff. So it's moving away from sort of the clerical model of court staff into actually specially trained. This may be something that you're going to have to spend some time with your judges on, of getting the permission to let your staff actually work with the judges in managing these cases.
And so in Los Angeles, we're trying to incorporate as much technology as we possibly can. I actually started in traffic, which we're not going to talk about today, but because we get about 1.5 million traffic citations every year and had just horrendous lines everywhere and a volume that was difficult. And so we started with business process reengineering there first, because I feel like jury and traffic are the two areas that really leave people with an impression on how you're doing. And so if I could fix that, our jury was running smoothly. It worked well. And we introduced an avatar, an online avatar that actually assists people in English and Spanish, and soon, over the next couple of weeks, Armenian, Mandarin, and one other language. And it walks people through, because again, we're finding that people are just not literate even in their own language in following the information. And so we will bring that avatar over to some of our self-help, even related to small claims and tenant-landlord issues and some of the others, because we found it has been so hugely successful. Just as an example, our lines went down from like 3 hours to 8 to 12 minutes, and the avatar gets about 5,000 interactions a week. That's huge. So if we can do the same to help some of the people that are currently coming down to the court to try to get some help, I think that would be a good thing, so they don't have to find babysitters or drive down. Yes? The court pays for the technology, but this avatar program was actually incredibly inexpensive, and for me it was worth it anyway. When I say inexpensive, I think the software itself is less than $20,000, and then it's just programming. So we do our own technology.
Okay.
Absolutely.
Part of the technology is sort of looking at sort of the litigant portals and how the litigants actually get in there and get their information. Another aspect of the technology is actually looking at your case management systems and the automation. Are you actually using those systems to help monitor your cases so that you don't have cases that are sort of falling off the tracks and nobody knows where they're going. So this is one that, and part of the recommendations, and we've got tools actually that you can take back to your IT people and say, here are what our case management system ought to be doing. Can you build this in? So that you can take it back to your vendors or to your IT people to develop those tools.
That's going to be a great document, I think, for all of us, because right now the vendors are, they need an encouragement to build what the courts need rather than what they think we need, I think is the best way to say it. We're also doing things like allowing people to have text and email reminders of upcoming dates. We're developing, which I'm sure a lot of you are too, electronic pathways or programs that will help triage the cases when they're initially filed, which will populate the mandated complex forms with information from simple questions. And so we're developing all of that now as we move to new case management systems. So for me, we really need to find a way to process, for me, the 93% of our total civil filings without a lot of judicial involvement until the point we need a judge. But if we can do that, now the judges are more available for the general cases and the complex cases rather than spending time on trying to massage these cases that tend to get lost through very busy dockets.
If I can just jump in and underscore how useful technology can be when it's a tool that's calibrated to the litigants, like the avatar, which I think is just brilliant. Technology to promote remote access, I think is really, really helpful for litigants and for lawyers to avoid, unnecessary trips to the courthouse for routine conferences. So I think that's something that folks should think about in this context. I think the texting and emailing notifications in this day and age are really important, and I think that using automation to require people, plaintiffs and defendants in these high volume cases, to fill out standardized forms that force them to provide the information that's currently missing could go a long way to reducing some of the abuses of the system. So I think when used wisely, technology can advantage cases all the way across the board.
Okay.
All right. So that's really about the high volume recommendations, that there's specifically one of looking at how do you manage those, and in part, really holding the cases accountable, so that you have an extra set of eyes on them.
So going back to kind of the big bulk of these cases are these high volume non-lawyered cases. In Los Angeles, we have one supervising judges who's over our small claims, collections, and tenant-landlord cases. He kind of manages them and makes sure that the judges talk weekly on uniform procedures, and the staff there too, to make sure we're processing them uniformly and that there aren't any problems. There were 145,000 matters that fell into these courts last year, and during that year, there were only 67 complaints from the public. That's amazing. That's for the whole county of Los Angeles, and only 80% of the 67 were unhappy with the result, which means they were just confused and didn't know they needed to file an appeal or what the process was. I believe that by managing these cases more efficiently together with specialized staff and judges with a process that helps the litigants, makes a better team, makes a better process, and it can burn out the judicial officers and the staff, so you kind of have to understand that you need to rotate them, but it certainly, I think, provides a better level of service to the public.
A last one is sort of this whole idea of the uncontested cases and the default cases. In some cases, obviously, before you enter a default judgment, have somebody actually looking at that. We've talked about this. But there are other cases that just, failure to prosecute. You find them 2 years later that they're still open and nothing has happened. And so one of the recommendations is just start looking at those cases. If nothing has happened, or if the deadline has passed for something to have happened, something to have been filed and it hasn't, then there needs to be a sort of an automated process, and use your technology and use your staff for this, to say, hey, This was due, a month ago. It's not here. Either file it in the next 30 days or 14 days or, whatever your time frame is, or we're going to dismiss it. And when you think about sort of that timeliness issue, I mean, the cases that were just sort of dismissed for failure to prosecute were some of the ones that were actually really hurting your standards. I mean, if you can actually take care of these uncontested cases and either move them forward or dismiss them, you'd actually probably be meeting some of those time standards.
Actually, a lot of what you said
Mm-hmm.
is, I don't know, you might be familiar, there's a national committee now looking at, I hate microphones. There's a national committee now looking at changing standards for processing civil cases to actually put time standards so the courts are actually responsible for moving the cases forward and no longer the attorney, which is going to change the way that we handle.
Who's the national group?
I forget what group it is, but one of my judges sits on that committee, so I've been privy to read
Okay.
what is going to be coming out probably in a year or so, and it just totally validates what you're saying. You know, the triage in the beginning is very important. Pathways, you have to be careful a little bit, because if you have a judge that has worked 90% of that case and 80% of the defendants are closed out, you don't want another judge to relearn the case. That takes a long time, and it goes to judicial efficiency. But a lot of what you're saying is going to be validated in this document that's going to come out that we should all probably adopt in some way or another.
Good. Excellent.
And you don't necessarily have to change judges, you just change pathways. Right, so that's kind of one of the beauties of this too, right? Yeah. So the access to litigants, I think we've talked about this enough. I wanted to tell you one other unique way that Los Angeles is trying to handle many of these civil cases is that we're looking at partnering with the LA County Department of Consumer and Business Affairs. They have got probably one of the best online dispute resolution programs I've seen. It has a video component where the mediator can talk by remote video, which goes to Hannah's point that maybe these people can't afford to come down, but maybe they could FaceTime or go somewhere where there's a camera, where they can put one side on hold and just talk individually with one side and then bring the three of them together. They have real-time chats. They have back and forth bidding, which will say, well, okay, I would take 600, and the other person will say, no, I'll offer you 550. How about 575? And after about 6 online bids, if they can't agree on a price, then it'll come back to the mediator, and it allows uploading of documents. So right now we're kind of in discussions on if there's cases that we should mandatorily send there or not, as a process to help them rather than coming down to court.
The other one that, sort of back to the technology, that a lot of courts are starting to look at, and actually a lot of the e-businesses are like light years ahead of us, is online dispute resolution. Amazon and PayPal and eBay have had them for a decade. I saw a demo of them. They're pretty impressive. Utah is planning on building their own online dispute resolution, but that can actually, have a couple of different things where you can do the negotiation. You can have somebody actually decide the case, have a judge decide it. You can upload the documents, and so sort of the access as well as the framework that can actually help even the playing field somewhat is quite intriguing.
And this is you.
This is me. So the last one is just sort of on action plans. 2 weeks ago, the committee that we're all involved in actually presented these recommendations to the Conference of Chief Justices at their mid-year meeting. We were remarkably happy that the chiefs who were there liked the recommendations and thought that they were important and needed to move forward. Their 2 biggest questions that they had were, how do I sell this to the trial bench, and how do I sell this to the bar? Those are the big ones that they're looking for. I'm happy to say that we are developing additional tools that can help make the implementation easier. But some of them are just sort of, what is your action plan at a statewide or at a local level? I would suggest that one of the things that you probably want to do, if you haven't already done it, I think most of you were kind of like nodding as I was talking about the landscape data, do your own landscape. What does your civil caseload look like? So that you're not sort of in that same thing where, frankly, I think everybody on the committee was that the docket in the head is not matching the docket that's actually in the courts. And so that you've got a sense of where do we need to be spending more time? Where are the bulk of our cases? What are the problems there? Complex cases they are complex and they require additional time. There's no question about that.
Judicial time.
Judicial time, but they're also a small percentage. And if you're spending all your time there and ignoring the other 93% of your docket, you're not doing anyone any good. There's going to be tools. I mentioned, functional standards for case automation. Talk to your IT people. Talk with your vendors. How can we build this so that a lot of these things that are very routinely done can be done automated, and then feed it up to the people in the courts who actually need to do it. What kind of training for staff so that you actually can have effective team case management with the judge coming in when the judge needs to come in and make something that requires uniquely judicial expertise, but having team people. That's something I think that NACM could definitely be working on in terms of what kind of skills in the area of civil justice needs to be there, your core competencies that you've talked about in the past and worked on in the past. So all of these things are sort of going to be tools that are going to be available. We're going to be rolling them out hopefully over the next 6 months. But we'd very much like to have you folks here at NACM, because we know it, if the court administration is not on board, none of this is going to happen. The judges will not touch it. And if you're not on board, it can't happen. So
What I would like to, I know we've got to close, but I would like to get your thoughts. I really, as the court administrator on the panel, I would encourage you to read the recommendations. If there's anything there that you think just does not sound right, or you have a concern, or you have a suggestion, this is the time, right? They're draft right now, but they're not going to remain draft very long. So I'm looking at you because do we know when the final might?
We're hoping to have the final draft written and ready to go by the end of April at the very latest. So if you can read the recommendations and get comments, you can send them to me. My contact information is on the website and things like that. But just any comments that you have or suggestions or ideas, we would love to hear it.
So thank you.
And you will need the microphone to warn you.
So, other thoughts, questions? Yes, sir.
I think you're going to have a high likelihood of success. The UK has done much of this. 10 years ago, we did virtual plea and direction here. 10 years ago, we did money claims online, real property claims online, which brought everything down into a bulk processing center, one place in the whole country to do this. And it's basically the same types of cases, although money claims cases went up to £100,000. It's on a note. But 90% were summary judgment. So I don't think they put in the protections that you talked about up front. But the rest of it they did. Then there was a virtual plea and direction case progression system we built, which was basically just like what you said, taking active management of the cases. And this was actually for more complex cases. But the second an attorney, the day after an attorney didn't do something, there was a case manager right on top of them, basically a dashboard, green, blue, green, yellow, and red. Something went red, it took care of it, got it on, and they did it because they were having a horrible success rate with getting things to trial on time. So, and then the online dispute resolution, Her Majesty's court system is going to go to that for all cases under 25,000 pounds. And in the Netherlands, they've already moved to that for divorce cases. They have a upfront divorce case. And it sounds like you've talked to Colin. And
I have.
yeah, so, and Modria and their solution. So, you know, I think this is the way the courts have to go. In the civil side, they're losing to private justice. And we can either let it all go out the door, or we can fight for it and provide much better protections to the citizens, because they don't get that in private justice.
It's already being done in the other side, which is traffic. You know, in Virginia, you can have your trial online. You know, just either you go to a kiosk or whatever, and the judge will hear it. It'll take a couple of minutes. You get your jurisdiction, and you pay your fine. All there. So why wouldn't we go that way in county civil, which is another component that is easily done the same way. So, and I researched it's the National Center for State Courts that the judge is working on. The
Okay.
new,
Working with me, okay. Yeah, this
No
is
wonder your stuff sounded so
the
familiar.
right hand and the left hand. There's just too much stuff going on.
no wonder your stuff is being validated.
Good to know she's consistent.
There we go. Wonder who's working on that.
Well,
Marcus.
well, first, I just want to commend the effort. I think it's great you folks are here at this conference with the administrators, so thanks very much. I wanted to ask about the pathways, and I like this idea. It's not just dollar damages and so on. Are there criteria that the conference has thought about that would maybe help us if we want to look at, you know, kind of going beyond the classic sort of DCM model?
The criteria that we sort of put in for, and it was one of the slides, so you can take a
I
look at
pulled
this.
it.
But you get it up there.
Uh-huh.
So just sort of this idea with the streamlined pathway is these are the ones where the parties already have all the information that they need themselves. They don't need to be doing a lot of extra discovery. So you've got relatively few parties, routine issues, so nothing novel. You know, you're not trying to break new law or interpret, you know, some untested, you know, statutory provision. Very little discovery, and we keep talking about discovery being such a huge thing. Very few cases do a lot of discovery, even contested. There's just not that much, you know, the attorneys keep saying there's a lot of discovery going on. There's not a lot of discovery going on. They think they need this much because they might need to do that much discovery on some unusual case. But I actually heard one of my colleagues who was talking about the courts are really one of the only institutions in the world that actually design their system to around the event that is least likely to happen. You know, so the idea that we're designing this about a trial that actually very seldom takes place. And he was describing this with his wife who had had heart surgery last fall, and said, you know, there was a 2% chance that she wouldn't live through it. And if he was following a court model, he would have gone out and bought a funeral service from the local funeral director. But we don't do that. So why are we doing this in court? Why are we not sort of arranging about how cases normally go? Most cases don't need that much discovery. So that's sort of the idea. But complex evidence, complex law. Logistically, so there's lots of parties, maybe lots of lawyers. Maybe it's a multi-jurisdictional type thing or mass tort type of thing, or very high interpersonal conflict. You all know those cases where the lawyers are just going to fight for the sake of fighting. But if you have your case management system sort of on tracking this stuff, and this is the second or third motion to compel that's coming up, that's going to click it, even if it's sort of a low-level auto tort, that would sort of go in your streamline, that's going to kick it up and say, okay, a judge needs to get these guys in here and talk to them about what's going on, because they're clearly not, that's the level of complexity that requires a judge's attention to say, knock it off, guys.
Our complex court recently had in the complex court, a huge case with a lot of parties because employees were suing due to the denial of meal and rest breaks. Not a lot of money there. lots and lots of parties to manage. And so if we would have used the value, the value of the case as a way to tag it, it probably would have fallen down to the bottom because there's not a lot of money there. But just the number of people they had to manage, it had to go to our complex court. So again, I like not using the value. The PI case that I said was $1.6 million against Costco was in our Streamlined Cases. It had 5 hearings. So it does not, using value, which is something that we all kind of are used to a little bit, is just not been the best way to put them in a pathway. And the streamlined and the complex are almost easy to find. Everything else just kind of falls into general until it needs to move up or down, one way or the other.
Mhm.
So
But sort of when we've been looking at the evaluations that I've done in New Hampshire and in Utah and working with Texas now, if you have fewer than 85% of your civil cases in Streamlined, you're not capturing enough. You really should have 85% or better. LA was 93%. And if you've got more than 3% in complex, then you're over capturing in your complex. And this is the thing that hindsight is 20/20. If I had to go back again, I would say, forget this. There has to be 3. There's 2. There's Streamlined and complex. But they said that there had to be this general one in the middle that for other stuff that doesn't quite fit. But
it works well for us because we have individual calendar courts that have those kind of general cases. They're not in our complex courts because we have 7 complex civil judges or courts that handle all of our complex civil cases, and then we have a lot of streamlined specialty courts and streamlined processes and rules, and then the individual calendars in the middle that do the general. So it works well for us.
okay. Okay. Other questions or comments?
Well, thank you.
Thank you.